have the pleasure to introduce the second keynote speaker of this conference. It's Fred von Lohmann. He's a senior copyright counsel at Google. And before that, he was a lawyer, senior lawyer at the Electronic Frontier Foundation. He did excellent work there at the Electronic Frontier Foundation. That's when we met a few years ago. And they were doing very interesting things in terms of privacy protection online, technology and copyright-related issues. And one of the things that history may prove him right was proposing an online music license for online, a compulsory license for online music. I'm always thinking that history will prove him right. Someday we may have an online licensing, compulsory licensing for online music. In the meantime, we don't. Anyway, we're very happy to have him here. We were saying yesterday that Google is shaking the world. He was not sure. He was saying perhaps the world is shaking us because we have so many lawsuits and claims all over the world. But what we are sure is that what Google and his peers and competitors are doing is something we need. We want search engines. We want news aggregation. We want social networks. We want all that. And perhaps copyright law is in the middle of it. And the first presentation, I think, was already pointing in that sense. So I'm not going to say any more. You have his curriculum in the website. Please, you're welcome. I'm very happy you accepted our proposal invitation to be here. We're going to listen to you.
Thank you very much, and it is always a very great pleasure to visit Barcelona. So thank you for the invitation and the opportunity to join you. Greg's talk just now was very interesting. I was tempted to do away with my talk and just answer the fascinating questions that Greg has raised. I myself worked on a number of the cases that he discussed when I was at EFF. But of course, I'm not going to do that. We'll have some time if you have questions. I want to talk about copyright from a slightly different angle, although I think we intersect in many, many ways. Copyright, for its essentially entire history, has been conceived of as a law about authors' rights. And of course, that is correct. That is not wrong. That has been its history and will continue to be an important part of copyright's job. But I want to persuade you, I hope today, that copyright has much more work to do today than it ever has done before. And in fact, copyright limited to a notion of authors' rights is not going to do the job. It is simply not enough for everything we are asking copyright to do in the digital environment. So the first question, of course, that arises is, if copyright is a law about authors' rights, which authors are we talking about? And Greg's talk, I think, was an excellent introduction to the fact that we have far more authors, far more creators today than ever before, far more creativity today than ever before. I had not seen the photograph that you had shown of all of the Flickr photos printed out from a single day, and what an enormous pile that makes. But I'm not surprised. In fact, I'm sure there are, I think, by last count, over 500 billion photographs hosted on Flickr. To give you a slightly different perspective for video creativity, today there are more than 72 hours of video, new video, being uploaded to YouTube each minute. To give you a sense, that means each month on YouTube there is more original video content than it has been created in the entire history of television in the United States, combined. Every month, more new video is created than all of the television programs that have ever been broadcast in the United States over the last 60 years. But in fact, even those numbers understate how many authors, creators we have, because copyright law itself now applies to so many more things than it used to. So not only do we have a situation where we have millions of new creators making YouTube videos and blogs and Facebook posts, but in fact, every email that you author is copyrighted because it is fixed in a tangible medium of expression. So literally today, effectively every citizen with a computer is an author that is, whether they know it or not, part of the copyright system. So that is one challenge that we face. How do we conceive of copyright law for literally everyone? Not just for publishers, not just for professional authors, not even just for amateur authors, but literally for every person who ever types an email. What would copyright law look like if we took seriously all of the needs of those authors? I would suggest that, in fact, today those authors care more about limitations and exceptions to copyright law than they care about exclusive rights in their emails and in their blogs and whatnot. But that is not all that copyright law is doing today. Today, copyright law is also being called upon to address innovation. If you are building a new company in the digital age, you are suddenly a copyright, you have to become a copyright expert. Whether you are making a product that has anything to do with music or movies or books, it doesn't matter. Because today, in the digital age, every use of a computer is going to require some copyright-related event because computers operate by making copies, transmitting copies, making copies accessible, and therefore companies like Twitter, like Facebook, like YouTube, like Google's own Blogger platform, here in Europe, SoundCloud in Germany. I understand there's a social networking platform in Spain called Tuente. These are all companies that have to think very hard about copyright. They have to ask every day the question, can we introduce a new feature? Not because we are interested in reproducing music or movies or any of that, but because every post, every email, every tweet, all of it is copyrightable and therefore raises many complicated copyright questions. So, in a way, without noticing it, copyright law has become our innovation policy. If you are interested in economic growth, if you are interested in the creation of new businesses, new companies in the digital space, copyright law must foster and encourage those activities. Copyright law is no longer just about authors' rights. It's about what kind of new business economy you want to have. Because in the digital age, one must make copies, and therefore copyright is involved. So traditionally, copyright law has thought about many of these questions as an issue of limitations and exceptions. And of course, limitations and exceptions to copyright's exclusive rights are very important. Many of them will be quite familiar. In Europe, as part of the European Copyright Directive, there is a list, a closed list of exceptions and limitations that are available for members of the European Union to add to their national laws. And of course, many of these are familiar, and there's no doubt that many of these are incredibly important. Exceptions for libraries, exceptions for press reporting, exceptions for quotation, parody, private copying, something which as an American I often am envious that many countries in Europe have a private copying right. We in the United States have struggled for many years to figure out how private copying fits into our copyright system. So these limitations and exceptions are no doubt very important and very deeply rooted in European copyright traditions. In fact, they of course came from all of the European local laws and were included in the directive. Of course, there are also new, deeply rooted practices that I think everyone today increasingly recognizes must be accommodated by limitations and exceptions. Search engines. Google obviously cares quite deeply about the legal position of search engines, But I think you've seen across Europe and also in the United States a clear recognition by courts and by policymakers that, of course, search engines are a good thing. We ought to have them. We don't want a copyright regime that makes search engines impossible. Because, of course, search in a world of an infinite number of videos and websites and blogs, search is an incredibly important public good that is something that people would like to see. Space shifting is now, I think, largely accepted as something that ought to be permitted. If you are able to see it on your computer, why should you not also be able to see it on your mobile phone? Why should you not be able to see it from any device that you have? There are other issues as well. Remix culture, something Greg discussed as well. I think today policymakers accept that if someone would like to make a remix of an existing work in order to comment or criticize or perhaps even just to express their admiration for a particular work, particularly for non-commercial purposes, I think we see a general acceptance that this kind of creativity is a good thing. We should not want a copyright law that makes it impossible. In fact, I was very gladdened, I was very pleased to see just last week, or 2 weeks ago now, I think, in Canada, they passed a new copyright statute. And one of the express limitations that was recognized in the new Canadian Copyright Act is an exception to allow remixing for exactly this sort of purpose. So we now, as far as I'm aware, it is the first national law express recognition that remixing for non-commercial purposes should be permitted within the copyright regime. So there is no question that limitations and exceptions are important, not just for where we have been, for traditional, deeply rooted activities. It is also, I think, increasingly recognized that we need limitations and exceptions to foster, to enable the activities that we already are seeing. However, I want to leave you with the idea that this is not enough. Because, of course, we need more than just to allow what has already been invented. What we need, I would submit, is flexibilities in copyright that go beyond a closed list of exceptions and limitations. What we need to worry about, if we believe that copyright law is for every citizen, as I mentioned, everyone who types an email, if we believe that copyright law is innovation policy, in other words, what companies will be created, what jobs will we have created in the new economy, we should be worried that copyright law be able to accommodate things that have not been invented yet. If we wait and we say, well, we know we like search engines, well, we know we like remixes of videos on YouTube, that is an approach that basically, ends up telling the world that you must get permission first, and then you can innovate later. And if the Internet and the rise of the Internet has taught us anything at all, it has taught us that that is not the way, that is not the way to getting the kind of innovation economy that you want. You have to leave room for experimentation. You have to leave room for new technologies to arise. So let me give you a couple of quick examples. It is, of course, very difficult to predict the future. The whole point of creating a flexibility beyond an express limitation or exception is to leave room for things that we cannot predict. But let me take a chance. Let me risk predicting a few things that I think we can expect coming very soon. The first set of examples, again, picks up on something that Greg talked about in his talk as well, is technologies related to indexing. These technologies are at their very infancy. You look at a search engine like Google, we attempt to index the more than 1 trillion web pages on the Internet. People sometimes think that indexing is a solved problem. Far from it. We have barely begun to index all of the information that is created today. So the one example that Greg mentioned is this iParadigms case, the plagiarism detection company. I think that is a very innovative and interesting approach. We can disagree whether it ought to be mandated for students or not. That is an area that I think is ripe for debate. But what I think we cannot disagree with is what a clever idea it is, and it is responding to an obvious need. Students have the ability to search the entire internet. That means they can find papers that were written by other students everywhere in the world, and teachers cannot be expected to read every paper and know whether the paper has been copied. So the ability to create this matching or this indexing, this search capability to identify papers is a great example of new kinds of indexing. Another example that I think is arriving already, I don't know how many of you have used apps like Shazam or SoundHound. These are applications on your mobile phone that allow you to simply hold up your phone if there's music playing, and the phone will be able to tell you what song is playing, who the artist is, what's the recording. The technology to make that work is incredibly sophisticated. The ability to actually match, to say, this sound recording that you're hearing over the noise of the bar, perhaps, is the same as that sound recording, is very sophisticated technology, and it depends on making copies of every single item that you are trying to identify. So how do we build a copyright law that recognizes indexing or identification as a valuable new capability? These are not technologies where the copies are being used for expressive purposes. For iParadigms, for example, neither the teacher nor the student would be able to actually read every other paper created by every student. When you use your mobile phone to detect a song, you are not thereby allowed to listen to the original recording. That is not the goal. The goal is merely to allow you to identify it. Yet copyright law, because all of these technologies depend on making copies, often has a difficult time distinguishing those cases because the copies are made and therefore copyright law can often step in. So I think those are just a few examples of what's coming as we try to figure out ways to allow you to identify every video, every piece of music, maybe every voice you've ever heard, the ability to help you figure out what is this like that, I think is something that is rapidly advancing. The other example that I think is now increasingly familiar, though I think we shouldn't forget how quickly this has changed as well, is cloud computing. And this is really the idea that you should be able to store all of your documents, basically all of the material that you have sitting on a computer, you should be able to store that in the cloud and access it from any device. Just this morning, I was looking at my notes for my talk. Those notes are on my laptop. They are also stored in Google Drive so that I can access them from my mobile phone, which is what I did this morning. I think consumers, I think computer users have already come to take this for granted. Enterprises as well. I think more and more companies are interested in having this ability to access documents from anywhere. What does copyright law have to say about that? Well, copyright law does not have a very good story for understanding these kinds of services. For example, if you make a copy of everything on your hard drive onto another hard drive as a backup, I think in Europe everyone would say that is a private copy and should be covered by the exception for private copying for those countries in Europe who have it. Of course, the UK, for example, today does not have a private copying exception. So in the UK, maybe you have difficulty even today with the question of how is it that you are allowed to back up your own computer. But if you live in a country in Europe that has a private copying exception, does it cover the ability to make a backup in the cloud? Instead of making a backup to a little hard drive that you hold in your hand, if you make a backup to the cloud, including every piece of software that is on your computer, perhaps including every MP3 file on your computer that you've purchased, all of these things are copied. What about the platform provider who provides you the service, how do these limitations and exceptions apply in this kind of new digital age? Copyright law is not terribly clear on those questions. So I guess the question then becomes, if you agree with me, if I've succeeded in persuading you that copyright law must serve new purposes and that flexibility is an important part, how do we accommodate things that have not yet been invented? How do we get there? What can we do? Well, there are a number of things that I'd like to suggest. First, I think there are, of course, things that courts can do. Just last month, here in Spain, the Supreme Court issued a very interesting opinion in the Pedrogosa case against Google. And in that case, the court recognized that search engines and the cache copy that Google has in the Google cache of websites that we have crawled, that's a good thing, that copyright law will allow that. And in fact, the court recognized that we need not rely only on limitations and exceptions to copyright. The court said we could bring in other points of view, common sense. I always welcome when the court decides that common sense has some role in the decision. And also the three-step test. There was a great flexibility there. We see this also in other court decisions. The ECJ, the European Court of Justice, has in 2 copyright cases this year also recognized that one can look to bodies of law outside copyright in order to inform when copyright law should apply. I think these are healthy developments. It is also, I think, crucial to recognize the importance of the safe harbors that in Europe are part of the e-commerce directive. These are incredibly important in making these new technologies available. I think it is fair to say that you could eliminate all the limitations and exceptions from your national laws, and most of the online services out there would probably still look similar because they would be relying instead on the safe harbors of the e-commerce directive. So it is true, I think, that Facebook, Google, all of the local European companies, SoundCloud, others, they are all relying on the safe harbor provisions every day to allow these platforms, these technologies that create opportunities for expression, to allow them to exist. So these are 2 ways to continue to protect these flexibilities. These are not technically part of copyright law, but in fact they are providing flexibility. The courts do it and the safe harbors do it. But I think there is more that can be done, and in fact 3 countries in Europe, I would say, are leading the way. They are the UK, Ireland, and the Netherlands. And the governments in all 3 countries have very specifically asked, how can we reform copyright law in order to encourage and foster new innovative companies? How can we conceive of copyright as an economic growth program for the 21st century? How can we make sure the next Facebook is founded in the UK? How can we make sure the next Twitter is founded in Amsterdam? These are the questions they are asking. And in the UK, this is being done in the Hargreaves process there. Many of you may have followed it if you are following copyright developments. Very interesting developments there. Ireland has a similar process underway, and the Netherlands as well. So there are 3 specific themes that are emerging in those consultations that I think are good ones to consider for all European countries. One is Article 5 of the Article 5 of the Copyright Directive. That is the article that is the so-called closed list of limitations and exceptions. What many researchers have found, particularly I would point to the works of Professor Zenstleben and Hugenholtz in the Netherlands, they have pointed out that there is more room for flexibility within that closed list than maybe some people had previously thought. And in fact, Professor Zenstleben has given the proposal that in fact perhaps the entire text of Article 5 should be transposed into national law directly. in order to give the maximum degree of flexibility that the directive permits. There are, for example, there's room in the quotation right, the quotation limitation, for a great deal more flexibility than many countries' laws currently include. The second theme that has been developed in these national efforts, reform efforts, has been a recognition that the adaptation right in European copyright law has not been traditionally has not been part of the copyright directive. So it has not been standardized across European law. So there is more room for individual countries to experiment. And today, if we talk about remixing on YouTube, for example, the adaptation right obviously has a lot to say. And there may well be opportunities to create limitations and exceptions for that kind of activity without running afoul of the copyright directive. And finally, a theme that has emerged in these reform efforts is how do we interpret the three-step test? The three-step test, of course, comes from the Berne tradition, now is part of TRIPS, and is included in the copyright directive that applies to members of the European Union. But there is still quite a bit of room to discuss how it should be applied. Can it, in essence, be used to permit flexibility rather than simply as an additional requirement, if you will, for existing limitations and exceptions? So I think these are three very promising areas for inquiry in Europe, notwithstanding the copyright directive. There have, however, been calls, and Professor Hargreaves' report in the UK included this theme, for actually revisiting, revising the copyright directive in Europe. Now, my friends in Brussels tell me that this kind of idea is a fine idea for thinking about in 10 years' time, that everything in Brussels takes at least 10 years, to which my answer is, well, then we'd better get started right away. And I think one of the things that Professor Hargreaves' report in the UK pointed out as an important area for potential revision of the directive is how do we allow copying for data analytics purposes? And I think this goes directly to my example about indexing and identification. How do we modify copyright law to create more room to encourage the creation of new technologies derived from analyzing large bodies of data? For if any of you have not seen it, Google has a fascinating little project called the Ngram Viewer. The Ngram Viewer is basically a tool that allows you to search every book. In our book search project, we have scanned millions of books now. You are able to search for the frequency of a particular word occurring across all of our texts. And many researchers have found this fascinating because it allows them to study the development of language, to say this word did not exist in all of the texts until roughly this time period, and then look how the popularity of the word has changed over time. In fact, I was quite struck. I don't know if Mad Men, the program, television program that is very popular in the United States, set in the mid-60s, it turns out that the scriptwriters for Mad Men use our Ngram Viewer to try to make sure they are not using words that are too modern in the script, because the show is set in 1963, 1966 now, and they didn't want to use any words that people did not know or did not use in that way in 1966, and they use our Ngram Viewer to check. And these are sorts of great new kinds of uses, research uses, scriptwriters' uses, that we need to be sure that these technologies can develop. So let me conclude by just again urging us to think about copyright law and all of the new jobs that we are trying to put on it, the new things that we want it to do. We want copyright law to address the millions, the billions of people who are online. We also want copyright law to encourage the creation of new digital businesses to create these new technologies. And again, certainly my push would be to move not just to doing limitations and exceptions, but to try to find flexibilities in copyright law to allow things that have not been invented yet. Thank you for your attention.
Any questions? Yeah, Greg, would you like to come here and join the... Any questions to Professor von Lohmann?